That meeting between you and the attorney is confidential. That attorney cannot share any information that he or she has learned through that meeting with you, regardless if you hire that particular firm or not. That firm, that particular attorney, is prohibited from disclosing any information that you discuss with him or her. So it is to your benefit to be able to be completely honest and forthright with that particular person, regardless of either how embarrassing or how damaging that you think what you're about to tell this particular attorney is. You need to be completely honest with that attorney. The attorney will be able to decide whether or not that is going to be advantageous or disadvantageous to your case. If it will hurt your case in any way, shape, or form, that particular attorney will be able to tell you, here's what we need to do, here's what you can expect, and here's what's going to be done. But without the complete full disclosure or transparency policy between you and the attorney, you're not really going to maximize that initial meeting, which is so important and crucial, because that's where it's going to be decided the course of action and take the strategy that needs to be done on your case. Because pleadings that are filed with the court dealing with family law matters, divorces, modifications, contempts, protections, or paternities, they're not an easy matter for the person who's going through them, and they're also a costly matter. So if you're going to be spending the time, the money, you want to make sure that you're completely honest with that particular attorney so they can zealously advocate for you on your behalf. Another thing that you're going to come into the meeting with, if not on paper, but at least have some type of mind frame of what you want to get out of this particular proceeding that's happening, or this particular plea that you want to file or that has been filed against you. Go in there and let the attorney know, here's what I want and here's what I will settle for. Because obviously you don't want to go in there with what your bottom line is. You want to go in there with what you want to try to get out of this case. Because that's not only going to help you, but that's going to help the attorney who's representing you to zealously advocate on your behalf. If that attorney doesn't know what you want, then there's a severe communication issue or breakdown between yourself and the attorney. And that needs to start from day one, referring back to the honesty, but also what are your expectations. Because when you go in there telling the attorney, here's what I expect or here's what I want, then that particular attorney can tell you, well, this is possible, this may not be possible, or this is impossible. Here's what we need to do to obtain your results. Here's what we need to do to start to help facilitate towards the goal-oriented settlement that we want to be able to draft. And in order to draft a settlement offer, we need to know what your goals, what your expectations are. So being able to bring those documents into the actual initial consult will be extremely beneficial to you and to the attorney and for the meeting, so both of you can be able to maximize the time together. When you meet with the initial meeting, we meet with the attorney. Usually it'll be in a conference room at that particular attorney's office, and usually be just yourself and that particular attorney. It could be one of the senior attorneys or a junior partner or a partner in the firm who may or may not take on your case, and they may assign it out, but they're going to be the ones who are diligently taking notes on what you're explaining to them, what you think the issues are, and what your expectations are. Based upon that, then that attorney will let you know, well, here's what you can expect, here's what I think the issues are based upon our initial consultation, and then move forward. From that meeting, that attorney could assign your case out to himself or herself or to one of the other associates in the office. And then your primary contact will be with the attorney that's assigned to your case, with the supervising attorney or the partner or junior partner looking over the case, making sure that things are getting filed with the court, making sure that you're completely satisfied, not just with the results, but with the way that your case is being handled within the firm. So once you have that initial meeting and you decide to retain, then that particular firm will send in to the court or file with the court, and if there's another lawyer on the other side, send to that lawyer what's called an entry of appearance. That's a document that dictates that we are the law firm that's representing this particular client, and that all communication needs to come regarding this particular person needs to come to my firm. And then based upon what's going on in that communication, that lawyer will contact you, and then the two of you can sit down and determine what needs to be done based upon what has been filed on your case. So once the entry of appearance has been filed, which states that this particular firm will represent you, then you go into drafting the responsive pleadings, which are the answers to any type of court document that you have been served with, and then potentially deciding whether or not you want to file any cross pleadings and get that on file. So it's important from that initial meeting moving forward that you bring the documents with you and that you're completely honest with that particular person, because that's only going to get you the results that you want. When you come into that meeting with the expectations, you have to be completely honest so that particular firm, that particular attorney can be able to get the results that you want. Once the first initial meeting has concluded, you will be contacted by the assigned attorney and then moving forward as indicated on drafting the responsive pleadings. Any court appearances can involve the partner or the assigned attorney to your case, but that will be decided upon at your initial meeting who will represent you in court, who will draft the pleadings, and who will primarily meet with. So once you go to this initial meeting, you've already made the first contact that you want to either proceed or help with something you've been served with. So keep in mind the documents that are important to bring will be the W-2, the tax documents, copies of any appraisals that you have on the marital residence or any other real property that you own, documents regarding retirement accounts, anything that would indicate some type of misconduct that you have, whether you've kept a journal, log, emails, or emails that you have from your spouse, pictures that your spouse has posted, or nowadays Facebook is popular or MySpace is popular. If you can go on their site and print out what they've had on there, that could be used against them. Also, anything regarding separate property that you have brought into the marriage or that your spouse has brought into the marriage. And again, most importantly, any type of legal document that you have been served with, you want to make sure that you bring those particular documents with you to the court. Unfortunately, we're out of time today, but please check on our website, DadsDivorce.com. You can click on the icon Ask a Lawyer question and submit any questions that you have. We'll try to answer them like we've done in today's episode dealing with initial consultations. We'll do our best to address all questions that are submitted to us. Continue to check out our website as we're continually updating it on a weekly or monthly basis. Again, that's DadsDivorce.com. Thank you.